Alright, I received information today for my arresting officers in West Milwaukee from the LESB. That's some kind of standardized training that they follow. And you just ask them, well, professionally using ChatGPT. And these are the training information. They've done a fair amount of redacting, but really revealing. This is something that Louisiana does not provide. But one thing that stood out to me was courtroom survival tactics. I didn't really think about it much in the past, but I need to because I'm dealing with trials coming up. And I wanted to ask I asked ChatGPT what they think of courtroom survivals for the police officers in general. And that's what I'm here to go through. I color coded everything, so it might be easier to read. But there's a lot of interesting information here that you could type into ChatGPT or maybe the other AIs and ask about as well, because this is a pretty in-depth like type of training. I think that officer got 8 hours of training to survive a courtroom. So you're trying to survive as a defendant, while the police officer is trying to survive themselves, and then the prosecutor's trying to survive. Judges maybe giving them the benefit of the doubt. So it's like they're saying the cops are saying that they're trying to survive, but you as a defendant, especially if you're pro se, you're trying to survive as well. So this is what cops are saying. Let me just I guess I didn't put a title on this yet. Let's see. Police court room survival. Alright. Cops receive training on courtroom testimony and witness stand tactics designed to make them appear credible, control the narrative, and avoid self-incrimination. Some key courtroom survival tactics they use include controlling their testimony, keeping answers short and direct. Officers are trained to give short, controlled answers to prevent revealing unnecessary information. Avoiding speculation. They are taught to only answer questions that they know rather than what they think. So it's about their professional answers and not their personal answers. Sticking to reports. They heavily rely on their written reports to avoid contradictions. Deferring to memory gaps. When pressed on details they don't recall, they often say, "I don't recall," rather than speculate. This is all in their training. Reinforcing credibility, projecting confidence. Cops are trained to appear professional, calm, and authoritative. Using key phrases, they repeat terms like standard procedure or training and experience to justify their actions. Maintaining eye contact. They make deliberate eye contact with the judge or jury to appear more trustworthy. Handling cross-examination. Avoiding traps. They are warned against agreeing to yes or no questions that might box them in. Reframing questions. If asked a tough question, they might rephrase it in their response to maintain control. Stalling for time. Taking a pause before answering allows them to think or recall what they were coached to say. Acting offended by accusations. If an attorney suggests misconduct, they may react with indignation to make it seem implausible. Avoiding self-incrimination. Playing dumb when necessary. If a question threatens to expose wrongdoing, they may claim ignorance or that it wasn't their responsibility. Minimizing mistakes. If caught in an inconsistency, they may downplay it as a minor memory lapse. Deferring to others. They often say I was following orders or it was the decision of my supervisor to deflect responsibility. Shaping the narrative. Using loaded language. They describe suspects as agitated or non-compliant, even if they were just asking questions. Portraying themselves as the victim. They may emphasize the dangers of policing or their fear for safety to justify aggressive actions. Exploiting vague terms. Words like furtive movements, unusual behavior, or based on my training and experience allow broad interpretations. Exploiting the court's deference to police, relying on judicial bias. Many judges give officers the benefit of the doubt, and cops are trained to use that to their advantage. Counting on jury trust. If a jury is present, officers may lean on their uniform and title to gain credibility. Using magic words, phrases like reasonable suspicion or probable cause are repeated to make their actions sound legally justified. Working with the prosecution, pre-trial coaching. Prosecutors often prepare officers by going over anticipated questions and responses. Cued testimony. Prosecutors may ask questions in a way that signals what the correct answer should be. Watching other testimonies. Cops sometimes observe their colleagues' testimony to stay consistent with their version of events. But that's why you're supposed to separate them. These tactics can make it difficult to challenge police testimony, but exposing inconsistencies, using their own words against them, and understanding their training can help counter their strategies in court. So with this, you're going up against extra trained cops because they will put at least 8 hours of training in Wisconsin as part of the LESB training. 8 hours of training on how to survive the courtroom. So that's what you're going up against. So it's something to just be aware of.